Greetings to everyone and welcome to Land Law 101. Today, we'll be discussing about the law of fixtures and fitting through the case of Abraham and Brenda. The dispute between Abraham and Brenda centers on the classifications of oil painting and sculptures as either fixtures or fittings that will be included within a property sales. The distinction is crucial in land law as it determines the ownership of the item in questions upon the transfer of the property. Under sections 205 clause 1 clause IX of the Law of Property Act 1935, the land is defined broadly to include corporeal hereditaments, which means the land and what is attached to the land. The main issue is to what extent we include the physical and intangible elements as part of the land. The Latin legal maxim quid plantato solo sedit, which further clarifies that items affixed to the soil become part of the property. The principle was established in the case of Minshall, reinforcing the general rules that anything attached to the land become parts of it. The key to resolve this issue lies in determining whether the painting and sculptures are fixtures or fittings. A fixture is defined as a chattel that is so affixed to the land or a building that it becomes part of the building or the land. Hence, it loses its character as a chattel and passing with the property. According to Section 62 of LPA 1925, when the land is sold, anything that is a fixture is sold with it. The purchaser is entitled to receive all fixtures, whereby the purchaser is entitled to receive all fixtures present at the exchange of contract as seen in Taylor's case, subject to the terms of the agreement. And therefore, to advise Abraham, it is essential to find out whether the oil painting and sculptures are fixtures or fittings. If deemed fixtures, the item will be part of the property and Abraham will have grounds to claim ownership. Conversely, if deemed fittings, Brenda will have retained the ownership as they are not considered parts of the property sold off to Abraham. It's obvious that the primary issue here is to distinguish between fixtures and fittings. In the case of Australian Provincial Assurance Co. Limited, quoting Jordan Chief Justice, a chattel is prima facie a fixture if it is fixed to any land by any means other than its own weight. It will prima facie not be a fixture if it is not fixed but kept in the position by its own weight. And this principle set the foundations for the annexation test, which helps to determine whether an item is a fixture or fittings. And the key to distinguish whether an item is a fixture or fitting is through the annexation test, which is established by Blackburn Justice in Holland case. The two cases are also defined in Hasbury Laws of England. The degree of annexations examine how firmly an item is attached to the property. It is a question of facts depending on the mood and extent of annexations, particularly whether the chattel can be removed without injury to itself or the premises. Blackburn Jr. also articulated this principle where he stated that items resting by his own weight are not fixtures unless intended as part of the land, with burden of proof of those asserting this. Conversely, items affixed even slightly are presumed fixtures unless intended to remain chattels, with the burdens on the claimants. The purpose of annexation test assesses the objects and purpose of attaching items to the property, whether for permanent substantial improvements or merely just temporary enjoyment. This test considers whether the items is intended to enhance the property permanently. As Scammon LJ in Berkeley case, he stated that a degree of annexations which in early times the law would have treated as conclusive may now prove nothings. If there is no physical annexations, there is no fixtures. Quid plantato solo sedit. Nevertheless, an object resting on the ground by its own weight alone can be a fixture if it is so heavy that there is no need to tie it into foundations, and if it were put in the place to improve the land. After explaining the test, let's apply it to the sculpture in the questions. They are made from marble and are extremely heavy, suggesting that they rest on their own weight. In Ham case, items resting on their own weight were regarded as chateaus due to lack of permanence. However, this can be rebutted by examining the purpose of annexations. These sculptures are not fixed to lands but rest on their own weight. According to Holland's case also, the onus is on showing that they were intended to be part of the land, while their physical removal would not cause damage. Their conceptual removal will cease their intended purpose of increasing the overall property aesthetics. In Berkeley case also, it was held that an object resting on its own weight could be a fixture it placed to improve the property. Although the sculpture rested on its own weight, their purpose was to enhance the property permanently, and this aligns with the principle in Berkeley, where the purpose of annexations can override the degree of annexations. Moving on, let's apply it to the oil painting in the questions. Abraham noticed that the property was tastefully decorated with exquisite painting from the Victorian era. The painting were hung on the wall and could be easily removed, indicating that they were prima facie chateaus under the degree of annexations test. The key consideration here is that ease with the painting can be removed, suggesting that they are not intended to be the permanent fixtures of the property. This aligned with the case of Lake and Taylor's, where tapestry affixed for personal enjoyment were considered chateaus. However, the purpose of annexations also needs to be considered. The fact provided does not clearly show that the painting were intended for personal enjoyment or to enhance the property aesthetical value permanently. If the painting were intended merely for personal enjoyment, this would reinforce their classifications as chateaus. Conversely, if the painting were meant to be increasing the property value, they will be fixtures. The subjective intention to enhance property could override the objective assessments based on the removable nature. Therefore, the crucial factors is determining whether the painting were intended to remain as a personal items or to integral to the property characters and value. The lack of details facts, of course, regarding this case makes it a little bit challenging to define and classify them. However, based on the information provided, it is more likely that the painting were mainly intended for personal enjoyment, given the absence of any indications that they were meant to improve the property permanently. Since the painting can be easily removed and there is no evidence suggesting that they were meant to be permanent fixtures enhancing the property value, they are likely to remain classified as chateaus. Therefore, the oil painting would not be included as part of the land and will remain a personal property and not transfer with the sales of the property. It's also very important to note that there is another issue arise from the fact that Brenda stated that the value of this painting and sculptures is high and it does not make sense for her to include the same together with the sales of the property. Her subjective intention to it does not determine whether these items are fixtures or fittings. In the case of Dixons and Fishers, Lord Cockburn established that no man can make his property real or personal by merely just thinking it so. This means that the classifications of an items as an fixtures or chateaus must be viewed objectively, not based on the subjective thoughts of intention of the party involved. Therefore, Brenda's belief that it does not make sense to include the item due to their high value can be disregarded. The subjective intention of the party, while potentially informative, does not affect the objective determinations of whether a chateau become a fixtures. The analysis must rely on objective criteria such as the degree and purpose of annexation, rather than personal views of individuals involved. Thus, Brenda's subjective reasoning about the value of the painting and sculpture does not preclude them from being fixtures if they met the objective criteria established by the law. Well, finally, after classifying the paintings and sculptures as fixtures and chateaux, it is essential to consider the implications by Taylor's case. In this case, Abraham decided to purchase the property and communicated to Brenda. However, during the finalization of the sales, neither party discussed the inclusions of the paintings and sculptures, and these items were not mentioned in the sales agreement. The situation mirrors Taylor's and Hammond's, where the sales agreement did not explicitly address certain items. In Taylor's case, the court ruled that deemed inspection does not apply when the vendors act fraudulently. As Lord Justice Linley stated, simple morality says that he cannot remove them without telling the buyers, and it was cheating of doing so. This ruling emphasized the vendors cannot remove the items that the buyer reasonably expect to be included. Additionally, there is possible misrepresentations by Brenda when she was asked by Abraham if the painting and sculptures is included. She replied vaguely, and that they could discuss further if Abraham sealed the deal immediately. Although this is not the main issues, but Brenda's response could have misled Abraham into believing that the items is included into the sales. Applying this case to Abraham's case, even though the sales agreement did not explicitly mention that the painting and sculpture should be included, Abraham thus has a reasonable expectation that they were included based on their presence during the inspections. And Brenda's vague response and the high value of items do not override the objective criteria used to determine whether they are fixtures, and consequently, if the painting and sculpture meet the objective test and becoming a fixtures. Consequently, if the painting and sculpture meet the objective test of annexation and purpose, they should be considered fixtures and be included in the sales as part of the land. In conclusions, to advise Abraham, the classifications of the stone sculptures and oil painting depending on the objective test of annexations and purpose. The stone sculptures, being extremely heavy and strategically placed to enhance the property aesthetics, are likely to be considered as fixtures based on the degree and purpose of annexations. Conversely, the oil painting, which are easily removable and primarily for personal enjoyment, are likely to remain chateaus. Brenda's subjective intentions and high value of the items also does affect these decisions. Abraham will have a strong argument that the stone sculptures should be included in the property sales as fixtures. For oil painting, further evidence of intended purpose would be necessary to classify them definitely, but for now, it will still remain as chateaus and being part of the personal property of Brenda. If Brenda removes this item, Abraham can seek remedies from misrepresentations under the Misrepresentation Act 1967, or claim a breach of contract for failing to include fixtures in the sales, and pursue equitable remedies such as specific performance or compensations for the diminish of the value of the property. And it concludes the Land Law 101 of today, and thank you.